Next episode
Successful knowledge transfer involves neither computers nor documents, but rather interactions between people. Thomas H. Davenport. Good morning to one and all present here. It gives me great pleasure to welcome you all to this national seminar on Consumer Protection Act 2019, the strengths and challenges, organized by KLE Society's Law College in association with Chair on Consumers Law and Practice, National Law School of India University, Bengaluru. We now begin the program by invoking the blessings of God. I now call upon Ms. Sushma R. Patil and Ms. Isha Venkatesh for the invocation song.
ನಿನ್ನಷ್ಟು ಬೇಕೆನ್ನ ಹೃದಯಕ್ಕೆ ರಾಮ, ನಿನ್ನಷ್ಟು ನೆಮ್ಮದಿಯು ಎಲ್ಲಿಹುದು ರಾಮ. ಇನ್ನಷ್ಟು ಬೇಕೆನ್ನ ಹೃದಯಕ್ಕೆ ರಾಮ, ನಿನ್ನಷ್ಟು ನೆಮ್ಮದಿಯು ಎಲ್ಲಿಹುದು ರಾಮ. ರಾಮ 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 ರಾಮ. ನಿನ್ನಿಷ್ಟದಂತೆನ್ನ ಇಟ್ಟಿರುವೆ ರಾಮ, ನನ್ನಿಷ್ಟದಂತೆಲ್ಲ ಕೊಟ್ಟಿರುವೆ ರಾಮ. ಕಷ್ಟಗಳ ಕೊಡಬೇಡ ಎನ್ನಲಾರೆ ರಾಮ, ಕಷ್ಟ ಸಹಿಸುವ ಸಹನೆ ನನಗೆ ರಾಮ. ಕಷ್ಟ ಸಹಿಸುವ ಸಹನೆ ಇನ್ನಷ್ಟು ರಾಮ, ಕಷ್ಟ ಸಹಿಸುವ ಸಹನೆ ನಿನ್ನಷ್ಟು ರಾಮ. ರಘುರಾಮ 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 ರಾಮ, ರಘುರಾಮ 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 ರಾಮ. ಋತ ನೀನೆ ಋತು ನೀನೆ ಶ್ರುತಿ ನೀನೆ ರಾಮ, ಮತಿ ನೀನೆ ಗತಿ ನೀನೆ ಧೃತಿ ನೀನೆ ರಾಮ. ಆರಂಭ ಅಸ್ತಿತ್ವ ಅಂತ್ಯ ನೀ ರಾಮ, ಪೂರ್ಣನಿ ಪ್ರಕಟನಿ ಆನಂದ ರಾಮ. ಹರನೀನೆ ಬ್ರಹ್ಮನಿ ರಾಮ, ಹರನೀನೆ ಬ್ರಹ್ಮನಿ ರಾಮ. ಗುರು ನೀನೆ ಅರಿವು ನೀ ರಾಮ, ಗುರು ನೀನೆ ಅರಿವು ನೀ ರಾಮ. ರಘುರಾಮ 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 ರಾಮ, ನಗುರಾಮ ನಗರಾಮ ಜಗರಾಮ ರಾಮ.
Thank you, Sushma and Isha, for the divine rendition. I now request Dr. Anita MJ, Academic Coordinator, to deliver the welcome address.
Good morning. Respected Honorable Mr. Justice R. Agrawal, President, National Consumer Disputes Redressal Commission, New Delhi. Dr. Sm Kantikar, Member, National Consumer Dispute Redressal Commission, New Delhi. Dr. Ashok R. Patil, Chair Professor, Chair on Consumer Law and Practice, NLSIU, Bengaluru. Dr. J. Malika, Janaya, Principal. Invitee guests, delegates, staff, and my dear students. Today we have gathered here for the inauguration ceremony of National Seminar on Consumer Protection Act 2019, Strengths and Challenges. On this occasion, I am privileged to welcome the dignitaries of today's function. First, I would like to extend a very warm welcome to Chief Guest of today's function, Honorable Mr. Justice R.K. Agrawal, President, National Consumer Disputes Redressal Commission, New Delhi, to today's function. Welcome, sir. Now I request Mr. Madhusudan, Assistant Professor, to present a bouquet to Honorable Justice. Thank you, sir. Now, I would like to extend a very warm welcome to guest of honor of today's function, Dr. Sm Kantikar, Member, National Consumer Dispute Redressal Commission, New Delhi, to today's function. Welcome, sir. Now, I request Mr. Tanmay, Assistant Professor, to present a bouquet to sir as a token of respect. Thank you, sir. Now, I would like to extend a very warm welcome to guest of honor of today's function, Dr. Ashok R. Patil, Chair Professor, Chair on Consumer Law and Practice, NLSIU, Bengaluru. Welcome, sir. Now, I request Mr. Praveen, Assistant Professor, to present a bouquet to sir. Thank you, sir. Now, I would like to extend a very warm welcome to our beloved principal, Dr. J. Malika, Janaya, to today's function. Welcome, sir. Now, I request Ms. Soumya, Assistant Professor, to present a bouquet to sir. I also extend a very warm welcome to invitee guests, delegates, staff, and my dear students. Thank you, one and all.
Thank you, ma'am. I now request Dr. Manoj Kumar V. Hiremat, IQSE Coordinator, to kindly introduce our honorable guests.
Good morning, all respected dignitaries on the days and off the days. I consider it my privilege to introduce today's chief guest and guests of honor of the event. Honorable Mr. Justice R.K. Agrawal, born on May 5th, 1953. Honorable Mr. Justice Rajesh Kumar Agrawal hails from Uttar Pradesh. He did his graduation in law from Allahabad University. His lordship, enrolled as an advocate in the year 1976, joined the chamber of his father, Shri Rajaram Agrawal, senior advocate, former Advocate General of Uttar Pradesh on civil side, and dealt with constitutional, company, service, educational, and taxation matters. His lordship worked as standing counsel of Income Tax Department, Government of India, served number of corporations and institutions as a standing counsel. His lordship was a joint editor of UP tax cases. His lordship was elevated as a permanent judge of the Allahabad High Court in the year 1999, assumed the office of Acting Chief Justice of High Court of Madras in 2013, and assumed the office of Chief Justice of High Court of Madras in the year 2013. He was appointed as Judge of Supreme Court of India in the year 2014 and retired from service in the year 2018. His lordship is presently serving as President of National Consumer Dispute Redressal Commission from 2018. With this brief introduction, I present Honorable Mr. Justice R.K. Agrawal to the august gathering. Welcome, Mr. Rai. Today is one of the guests of honor, Dr. Sm Kantikar, Member, National Consumer Dispute Resolution Commission. Sir is pathologist by profession. He is MD Pathology from VMGMC, Solapur, Maharashtra. Sir has PhD in law from National Law School of India University, Bengaluru. Sir started his professional career in Shimoga in 1989 and served there till 2013. In 2006, Sir joined as a founder teaching faculty of New Shimoga Institute of Medical Science and worked as assistant professor and associate professor. As a social worker, he started two voluntary blood banks, namely Red Cross Sanjeevani and Rotary Midtown in Shimoga. Sir was honorary professor in law and medicine in CVR National Law College, Shimoga. Sir was a member of the District Consumer Commission, Shimoga, for 4 years during 2003 to 2006. In the field of consumer affairs and law, he completed a research project on impact of the Consumer Protection Act 1986 on medical negligence, right to health, a human right perspective, and legal regime for safe blood. Sir is a resource person for national academic conferences and training program at various institutes like National Judicial Academy, Indian Institute of Public Administration, IIT, IIMA, etc. Sir was recently conferred with Karnataka Rajyotsava Award in the year 2021 by the government of Karnataka. With this brief introduction, I extend a warm welcome to Dr. Sm Kantikar. I take this opportunity to introduce briefly another guest of honor, Professor Dr. Ashok R. Patil. Professor Ashok R. Patil is BSc, LLB, LLM, and PhD from Karnataka University, Dharwad. Sir has experience of more than 22 years, and Sir also practiced as an advocate for 2 years in High Court of Karnataka. Sir started his career as a principal of Keli Society, B.V. Bellad Law College, Belagavi, then went on to become a chair professor on consumer law and practice that was established by Ministry of Consumer Affairs, Government of India in 2008 in NLSIU, Bengaluru. Sir is also a director of Online Consumer Mediation Center established by Ministry of Consumer Affairs in NLSIU. Sir has many awards to his credit. Sir has presented many national and international papers in international conferences. Sir is conferred with Legal Education Innovation Award 2013 in the year 2013 from Society of Indian Law Firms. Sir has launched the International Journal on Consumer Law and Practice, and to his credit, he has 13 books, 31 articles, 18 book chapters on consumer protection law and at national and international level. Sir has worked in the different capacities in different boards of the universities in Karnataka as well as across India. Sir is also in various bodies of UGC, NAC, BCI, and different academic bodies. With this brief introduction, I extend a warm welcome to Professor Ashok Patil. I request our principal, Dr. Malika, sir, to present memento to Honorable Mr. Justice R.K. Agrawal, sir, as a token of memory. I request Professor Ashok Patil, sir, to present a memento to Dr. Sm Kantikar, sir. I request Mr. Jayan, Assistant Professor, to present a memento to Professor Ashok Patil, sir. Thank you.
Thank you, sir. I request our chief guest, Honorable Mr. Justice R.K. Agrawal, to inaugurate the event by watching this happening. I request the other dignitaries to kindly join.
It brings me great honor to request Honorable Mr. Justice R.K. Agrawal President, National Consumer Disputes Redressal Commission, to kindly deliver the inaugural address.
Dear friends, a very good morning to all of you. I am extremely delighted to be associated and be part of today's conference and take this opportunity to convey my thanks to the organizing committee for inviting me to share my view on the topic Consumer Protection Act 2019, Strengths and Challenges. Friends, in the case of Prague Ice and Oil Mills versus Union of India, reported in 1978, Volume 3, Supreme Court Cases 459, our former Chief Justice of India, Mr. Justice Y.V. Chandrachud, has quoted, I said, quote, "The interest of the consumer has to be kept in the forefront, and the prime consideration that an essential commodity ought to be made available to the common man at a fair price must rank in priority over every other consideration," unquote. The role of a consumer is important in an economic system because the entire process of production and distribution takes place with the consumer in mind. Without consumers, the economic system would not function, as goods and services would generate no income. With growing competition and in an attempt to increase their sales and market share, manufacturers, sellers, and service providers may be tempted to engage in unscrupulous, exploitative, and unfair trade practices like defective and unsafe products, adulteration, false and misleading advertisements, hoarding, black marketing, etc. This means that a consumer might be exposed to risks due to unsafe products, might suffer from bad health due to adulterated food products, might be cheated because of misleading advertisements or sale of spurious products, might have to pay a higher price when sellers engage in overpricing, hoarding, or black marketing, etc. As a result, consumer becomes unsafe, feels cheated, and is exposed to many risks and health problems. Earlier, the maxim caveat emptor was used, which meant let the buyer be aware. In simple words, the maxim stated that the onus is on the buyer to see before the goods or services are purchased that they are in the proper condition. The buyer will assume the risk if the product or service fails to meet the expectation. Over the period of time, it was realized that the maxim caveat emptor was violating the rights of the consumer and was favoring the seller, even if any defective products were sold or deficient services were availed, as there was no liability on them for selling such defective products. It was this one-sided protection granted to the vendor alone which brought in the realization that the consumer should be considered as the king of the business and the rights of the consumer should be protected and promoted. The need for consumer protection arises from the need to protect consumers from the loss or injury or other prevailing malpractices and to ensure physical safety of a consumer, access to information, corporate social responsibility to provide quality and quantity of goods at fair prices, consumer satisfaction, social justices, and trusteeship and survival and the growth of business. Undoubtedly, Consumer Protection Act 1986 has served the purpose of legislation to a considerable extent in the last 3 decades with the 3 amendments made in the year 1991, 1993, and 2002, and lakhs of people benefited from it. But the modern market for consumers for goods as well as services have undergone drastic transformation with the emergence of global supply chains, rise in international trade, and the rapid development of e-commerce have led to not only plethora of products and services, but also new delivery systems, options, and opportunities for consumers. It has also rendered the consumer vulnerable to new forms of unethical and fraudulent practices and sale of products based on misleading information. Therefore, it was felt that the 1986 Act was not mitigating the purpose for which it was enacted, and a robust legal framework was required to regulate the industries and protect the interests of consumers. Keeping this in mind, and to address the new set of challenges faced by the consumers in the digital age, our Parliament on 6th of August 2019 passed the landmark Consumer Protection Bill 2019, which aims to provide the timely and effective administration and settlement of consumer disputes. The Consumer Protection Act 2019 has come into existence on 20th and 24th of July 2020. Keeping pace with the changing times and new legislation aims at protecting the interest and mass, the 2019 Act has made an attempt to overcome the lacunae of the 1986 Act by strengthening and broadening the scope of various provisions, including persons who can file a consumer complaint to also include class action. Some of the salient features of the 2019 Act are as under. While the 1986 Act was facing various difficulties with its implementation of various teleshopping and online transactions, the 2019 Act has removed any muddle on its applicability in similar circumstances. The scope of the application of the consumer law has been enhanced by the 2019 Act by modifying the definition of consumer. Explanation small b to subsection 7 of section 2 states that, I quote, the expression buys any goods and hires or avail any services includes offline or online transactions through electronic means or by teleshopping or direct selling or multi-level marketing, unquote. Further, to address emergence of global supply chains, rapid development of e-commerce, and to tackle misleading advertisements, telemarketing, multi-level marketing, and direct selling, the 2019 Act has attempted to define e-commerce. Subsection 16 of section 2 of the 2019 Act contemplates that e-commerce means buying or selling of goods or services, including digital products, over digital or electronic network. Similarly, subsection 17 of section 2 provides that electronic service provider means a person who provides technologies or processes to enable a product seller to engage in advertising or selling goods or services to a consumer and includes any online marketplace or online auction sites. The 2019 Act also empowers the center to make rules for preventing unfair trade practices in online trade. The term deficiency has also been redefined. As per subsection 11 of section 2 of the 2019 Act, the term deficiency shall also not include any act of negligence or omission or commission by such person which causes loss or injury to this consumer and deliberate withholding of relevant information by such person to the consumer. The new Act of 2019 highlights several provisions for simplifying the consumer dispute resolution process to ensure the speedy redressal of the consumer grievance and a quick protection of the rights. Some of the steps taken in this regard are: pecuniary jurisdiction of the consumer fora has been enhanced. When the 2019 Act came into force, the upper limit of pecuniary jurisdiction of the District Forum, State Commission, and the National Commission was increased from rupees 20 lakhs, rupees 1 crore, and above rupees 1 crore to rupees 1 crore, rupees 10 crore, and above rupees 10 crore respectively. However, by notification of the Consumer Protection Rules 2021, the pecuniary jurisdiction of the District Commission, State Commission, and the National Commission has been revised now up to rupees 50 lakhs, rupees 2 crores, and above rupees 2 crores respectively. Further, the term pecuniary jurisdiction has been defined in the new Act as where the value of the goods and services paid as consideration as against the earlier term where the value of goods or services and compensation, if any, claimed. Therefore, the compensation claimed by the complainant does not seem a factor in assessment of jurisdiction, as was held by a larger bench of the National Commission in the case of Amrish Kumar Shukla versus Ferris Infrastructure Private Limited, reported in Volume 1, 2017, CPJ, page 1. But the phrase paid as consideration seems to imply that the pecuniary jurisdiction is determined by what was actually paid already by the complainant and not the total value of goods or services. The National Commission in the case of Pyari Devi Chaviraj Steels Private Limited versus National Insurance Company, complaint case number 833 of 2020, decided on 28th of August 2020, where the complainant had obtained the insurance policy of rupees 41 crores and odd by paying only a premium of rupees 4 lakhs and odd, has held that the complaint is not maintainable before the National Commission for want of pecuniary jurisdiction. For a long time, a need was being felt to grant power of review of its order to the District Forum and the State Commission, and further lack of this power of review was causing unnecessarily proceedings, delay and expenses, especially when the case was dismissed in default. Now, under Section 40, 50, and 60 of the 2019 Act, the District Forum, the State Commission, and the National Commission respectively have the powers to review any of its orders, and if there is an error on the face of the record, either of its own motion or an application made by any of the parties within 30 days of the date of the order. To grant further relief to the consumers, the 2019 Act has included under clause D of subsection 2 of section 34, the place of residence of the complainant and the place where the complainant personally works for gain for determining the territorial jurisdiction of the consumer fora, thereby making it a wider and an easier approach. Provision for establishment of regional benches of the State Commission, the National Commission, has also been made in the new Act to deliver the inexpensive justices at the door of the poor consumers. Friends, though some of the state commissions have the regional benches, the National Commission is yet to have any regional bench. A complaint can now be filed electronically, and Section 36 of the new Act provides that the admissibility of the complaint shall ordinarily be decided within 21 days from the date on which the complaint was filed, and if the District Commission does not decide the issue of admissibility of the complaint within the period so specified, it shall be deemed to have been admitted. This provision also applies to the State Commission and the National Commission regarding fresh cases of complaint. In case of appeal, the party against whom any amount is ordered by the District Commission is now under the new Act required to deposit 50% of the amount ordered by the District Commission before filing an appeal before the State Commission. Earlier, the ceiling for the pre-deposit amount for filing appeal was a maximum of ₹25,000, which has now been removed. However, the National Commission, in the case of Mr. Sahyog Homes Limited and others versus Manoj Shah, decided on 12th of October 2020, has held that if the complaints have been filed before the implementation of the 2019 Act, that is 20th or 24th July 2020, the amount of precondition to entertainment the appeal has to be deposited in terms of the provisions of the 1986 Act. A similar view has been taken by the Honorable Supreme Court in a recent judgment in the case of ECGC Limited versus Mokul Sriram EPC JV 2022 SCC Online Supreme Court 184, decided on 15th February 2022. The limitation period for filing an appeal to the State Commission from an order of the District Commission has been increased from 30 days to 45 days. There is now a provision for filing a second appeal to the National Commission in the event where there is a substantial question of law involved. This is akin to Section 100 of the Code of Civil Procedure 1908. The 2019 Act proposes the establishment of a regulatory authority known as the Central Consumer Protection Authority. Section 10 of the new Act provides that the central government shall, by notification, establish with effect from such date as it may specify in that notification, a Central Consumer Protection Authority to be known as the Central Authority to regulate matters relating to violation of rights of consumers, unfair trade practices, and false or misleading advertisements which are prejudicial to the interests of public and consumers, and to promote, protect, and enforce the rights of consumers as a class. The very purpose to establish the central authority as defined under subsection 1 of section 18 of the 2019 Act is to protect, promote, and enforce the rights of the consumers as a class and prevent violation of consumer rights under the Act, prevent unfair trade practices and ensure that no person engages himself in unfair trade practices, ensure that no false or misleading advertisement is made of any goods or services which contravenes the provisions of this Act or the rules or regulations made thereunder, and ensure that no person takes part in the publication of any advertisement which is false or misleading. The central authority has been granted extensive powers to take suo motu actions, issue safety notices, order reimbursement of the price of goods or services, recall products, cancel licenses, and file class action suits if a consumer complaint affects more than one individual. The most potent and overreaching power of the central authority has been granted in the form of its power to conduct inquiries and carry out investigations. The central authority also enjoys sweeping and wide-ranging powers under the Act, which includes power to inquire or cause an inquiry into violation of consumer rights or unfair trade practices, either suo motu or on a complaint or on directions from the central government, cause investigation to be made by the Director General or by the District Collector if it is satisfied after preliminary inquiry that there exists a prima facie case of violation of consumer rights or any unfair trade practice or any false or misleading advertisement prejudicial to the public interest or to the interests of the consumers, call upon a person found prima facie to be involved in violation of consumer rights or any unfair trade practice or any false or misleading advertisements, and also to direct him to produce any document or record in his possession. Additionally, the Director General or the District Collector would have the powers of search and seizure under the Code of Criminal Procedure 1973, and also the power to direct production of any document or record, recall goods or withdraw services which are dangerous, hazardous, or unsafe, or direct reimbursement or of the prices of the goods or services so recalled, or discontinuation of unfair trade practices after giving the target person an opportunity of being heard, engage in and promote consumer advocacy, including by filing complaints before the consumer fora, intervening in any proceedings before these fora, recommending remedial measures, undertaking research, spreading awareness, and issuing safety alerts to consumers, issue directions after investigation to a trader or manufacturer or endorser or advertiser or publisher to discontinue false or misleading advertisement prejudicial to consumers, and to impose monetary penalties up to ₹10 lakhs, restrain the endorser of a false or misleading advertisement from making endorsement of any product or service for a period up to 1 year, or in case of subsequent contravention up to 3 years. Under Section 24, a person aggrieved by any order passed by the central authority under Section 21 may file an appeal to the National Commission. A new concept of product liability has been introduced in Chapter 6 by the 2019 Act, which was in dire need of. Subsection 34 of Section 2 provides for the product liability to mean the responsibility of a product manufacturer or product seller or any product or service to compensate for any harm caused to a consumer by such defective product manufactured or sold, or by deficiency in services relating to thereto. Sections 82 to 87 of the new Act deals with the procedure of product liability. The Act permits a complainant to make a claim of product liability against a product manufacturer or a product service provider, or even a product seller, for any personal injury, illness, death, or property damage resulting from defects in manufacture, construction, design, formula preparation, assembly, testing, service, warning, instructions, marking, packing, labeling of any product, etc. The product liability on a manufacturer has to be considered to be of stricter in nature to that of service provider and seller, as the manufacturer shall be liable even if he proves that he was not negligent or fraudulent in making the express warranty of a product. Insertion of product liability is a separate chapter, and a new ground for filing a complaint has been one of the most significant additions to the new Act. The definition of the product liability has very effectively brought online market within the ambit of Consumer Protection Act. Online retail platforms can be made liable for the products available for sale on their websites. The 2019 Act has also considered unfair contract, and it has been added, which further broadens the ground to file complaints and allows consumers to challenge contracts which are unfair, unilateral, and unreasonable. This is especially useful in the light of standard unilateral terms and conditions imposed upon the customers in various fields like housing, e-commerce, banking, etc. Another important feature of the new Act is that terms of a contract that are not fair to any consumer can be declared as null and void by the State Commission and the National Commission under subsection 2 of Section 49 and subsection 2 of Section 59 of the new Act, respectively. This will certainly assist consumers who are victims of one-sided agreements or unfair trade terms and conditions imposed by the seller. To meet the objective of providing speedy, inexpensive justice, especially to small consumers, as observed by the Supreme Court in a catena of judgments, it is absolutely necessary that extensive use is made of the alternative dispute resolution. In order to achieve the said object and purpose of the Act, and to regain the confidence of the poor consumers in the consumer fora with regard to speedy and inexpensive justice, a new chapter, Roman 5, on mediation as an alternate dispute resolution mechanism has been inserted. The new Act mandates the attachment of to the consumer fora of a mediation cell and reference thereto of any complaint upon its admission if it appears to the concerned district, state, or national commission that there exists elements of a possible settlement between the disputing parties in the complaint. Subsection 25 of Section 2 of the Act provides that mediation means the process by which a mediator mediates the consumer disputes. With regard to reference of a consumer dispute to the mediation, Section 37 deals with it. Similarly, Sections 74, 75, and 80 deal with establishment and composition of consumer mediation cell, procedure of impanelment of mediators in the mediation cell, and settlement through mediation. Further, Section 81 of the 2019 Act prescribes the procedure to pass suitable orders for recording such settlement. The 2019 Act has further provided the definition of misleading advertisement in a very wide term, and the central authority has been empowered to impose a penalty of up to rupees 10 lakhs on a manufacturer or an endorser for a false or misleading advertisement. The central authority may also sentence them to imprisonment for up to 2 years for the same. In case of subsequent offense, the fine may extend to rupees 50 lakhs and imprisonment up to 5 years. The central authority can also prohibit the endorser of a misleading advertisement from endorsing that particular product or service for a period of up to 1 year. For every subsequent offense, the period of limited provision may extend to 3 years. Now, the central authority in this background has, as all of you may be aware, banned the advertisement of one toothpaste known as Sensodyne on the ground of misleading, that the doctors cannot make any endorsement. The 2019 Act aims to bring in stringent measures so as to effectively protect the consumer's right. It, for the first time, provides for remedies that are criminal in nature by way of criminalizing few wrongs. The 2019 Act has recognized certain wrongs committed against consumers as crimes. It seeks to increase the culpability of the offenses that may be committed against the consumers and have made the penal provisions more severe and deterrent for non-compliance of the interim orders. It has attempted to bring the Consumer Protection Act under the ambit of criminal jurisprudence. Section 71 states that every order made by a consumer forum shall be enforced by it in the same manner as if it were a decree made by a court in a suit before it, and the provisions of Order 21 of the first schedule to the Code of Civil Procedure 1908 shall, as far as may be applicable, subject to the modification, that every reference therein to the decree shall be construed as reference to the order made under the Consumer Protection Act. Subsection 1 of Section 72 further provides that whoever fails to comply with any order made by the consumer fora shall be punishable with imprisonment for a term which shall not be less than 1 month, but which may extend to 3 years, or with fine which shall not be more than less than 25,000 rupees, but which may extend to 1 lakh rupees, or with both. However, there are certain aspects which have been missed the serious consideration of the 2019 Act. A question may arise as to whether the 2019 Act is still applicable to the healthcare services or not, as it has not specifically been excluded from the Act. The principles laid down by the Honorable Supreme Court in the case of Indian Medical Association versus VP Shanta, 1995 Supreme Court Cases, Volume 6, page 651, may still be applicable. Recently, the Bombay High Court, in public interest litigation number 58 of 2021, titled Medicos Legal Action Group versus Union of India, decided on 25th of October 2021, has held that mere repeal of the Act of 1986 by the 2019 Act without anything more would not result in exclusion of healthcare services rendered by doctors to patients from the definition of the term service. Against the said order, a special petition was filed before the Honorable Supreme Court, and while affirming the order passed by the Bombay High Court, it has been held that the PIL is motivated. The scope of the central authority and the consumer fora with regard to cases of a certain class has not been specified, which may result in clash between them. On introduction of the concept of product liability, there may be frivolous claims solely on the basis of discrepancies in designs, even when it results in no actual damage to the consumer or is done in order to improve functionality. Now, the pecuniary jurisdiction has to be determined on the basis of consideration actually paid. Such a reading may impact the flat purchases where the value of the property is more than the consideration paid. The 2019 Act prohibits referring of matter of medical negligence negligence to mediation. There is no provision in the new act imposing a penalty for unsafe products and services which lead to large-scale deaths and injuries in the country. The Consumer Protection Mediation Rules 2020 provides that the matters relating to proceedings in respect of medical negligence resulting in grievous injury or death cannot be referred to mediation. It would not be out of place to mention here that recently some of the landmark decisions passed by the Honorable Apex Court will certainly have bearing on the decisions of the consumer fora and be a fatal weapon in protecting the rights of the consumers. The Honorable Supreme Court, in the case of Karnataka Housing Board versus K. Nagmani, reported in 2019, Volume 6, Supreme Court Cases 424, has held that no revision petition is maintainable before the National Commission against any order passed under Section 27, Capital A of the Act of 1986 as the complaint is not pending. In the case of New India Assurance Company Limited versus Hill Multipurpose Cold Storage Private Limited, civil appeals number 10941 and 10942 of 2013 decided on 4th of March 2020, it has been observed by the Apex Court that the consumer fora has no power to extend the period beyond 45 days for filing written statement by the opposite party. Further, in the case of Nina Aneja and another versus Jayaprakash Associate Limited, civil appeal number 3766 and 3767 of 2020 decided on 16th of March 2021, the Honorable Supreme Court has held that all the complaints which have been filed before the commencement of the 2019 Act shall not be transferred, but shall be heard and decided by that commission before which it has been filed and is pending. The Honorable Supreme Court, the Mehra Bal Chikitsalaya Evam Navjat Sishu ICU versus Manoj Upadhyay and others, SLP number 4127 of 2021, decided on 12th of March 2021, has held that in view of the decision in Sicily Kala Kai versus Vehicle Factory 2012 Volume 8 SCC 524, writ petition is not maintainable before the High Court against an order passed by the Consumer Fora. However, recently the Honorable Supreme Court in the case of Ibrat Faijan versus Omax Build Home Private Limited, civil appeal number 3072 of 2022, decided on 13th of May 2022, has held that an order passed by the National Commission in Appeal under Section 58(1) small a Roman 3 of the 2019 Act can be challenged in a writ petition filed before a High Court under Article 227 of the Constitution of India. Further, in the case of Sunil Kumar Mehti versus State Bank of India and another, civil appeal number 432 of 2022, decided on 21st January 2022, the Apex Court has observed that the revision jurisdiction of the National Commission is extremely limited. Recently, in the case of Brigade Enterprises Limited versus Anil Kumar Virmani and others, civil appeal number 1779 of 2021, decided on 17 December 2021, the Supreme Court has held that if in respect of some of the towers, some person approached the consumer fora, and in respect of other towers, no person approaches the consumer fora raising the grievances, then order under Section 12(1)(c) of the Consumer Protection Act 1986 cannot be passed, and the said persons cannot be permitted to file a complaint in a representative capacity, and only a joint complaint under Section 12(1)(a) of the Act is maintainable. Friends, the strength of the Consumer Protection Act 2019 is that it has focused on enforcing the consumer rights along with timely and effective administration of consumer disputes. Certainly, the new Act is more in tune with modern day concepts of consumer protection, new market dynamics, and developments in the digital age. It deals with unfair contracts and e-commerce issues. It provides for e-filing of complaints and product liability suits. It also provides for mediation in addition to the earlier system of consumer justice and empowers the central authority or the regulator to recall unsafe goods or services, order reimbursement of their prices, put a stop to unfair trade practices, including false and misleading advertisements, order investigations into violation of consumer rights, and in general promote, protect, and enforce the rights of consumers as a class. In short, the new Act has incorporated several provisions pertaining to the determination of liability of manufacturers, service providers, e-commerce companies, electronic service providers, endorsers, and hence set standards for them to be more vigilant in their commercial obligations towards their respective consumers at large. Last but not the least, the changes that have been made in the 2019 Act will certainly ensure a safer and fairer market for the consumers to interact with the providers, but to what extent, only time will tell. Friend, these are some of my views. I am still a learner, and I will welcome any suggestions which may come to your mind so that it may be considered and improved. Thank you very much.
Thank you, sir. Your words have greatly enriched our knowledge. I would like to request our guest of honor, Dr. Sm Kantikar, Member, National Consumer Disputes Redressal Commission, to kindly address the gathering.
Good morning, everyone. Honorable President of NCDRC. And I will consider all three gurus here. One is from NCDRC, one is from my teacher, and Dr. Malika, he is also guru. I take all as guru and you all also. In few minutes after this just introduction, we'll start the talk proper after tea break. So this is very nice national seminar on consumer protection 2019. I think Lordship has elaborated on 2019 Act. Still in everybody's mind, there is a 1986 Act. There are students, there are practicing advocates, teachers, faculty, and learned members. So there are many changes. Consumer, it is a beneficial legislation. And there are many changes. Consumer friendly, what I say in short words. So we'll deal with that. And the organizers, your principal has assigned me to talk on medical negligence. Somewhat tricky subject, new subject, which will help the students and practicing advocates. So this is my area. It was my passion. So I did my law, then further education. And for the last 8-9 years, I am in the National Commission. So I will really share my experience on medical negligence, how the cases are filed, and as a lawyer, prospective lawyers, how you should deal, because you have to deal with both the complainant and the opposite party also. Therefore, with this brief, I think let us move to Dr. Ashok Patil's small speech, and then we'll start the actual session. Thank you. I'm happy to be with you all here. Thank you.
Thank you, sir. I now request our guest of honor, Dr. Ashok R. Patil, Chair Professor, Chair on Consumer Law and Practice, NLSIU Bangalore, to kindly address the gathering.
Thank you very much. Respected Justice Agarwal, sir. Respected Kantikar. Respected my friend, Principal of KLE Law College, Malika, Janaya. So already you heard our President's speech, who has covered all main important points under the new Consumer Protection Act. Just I wanted to go before 2019 Act. So what is the gap from 86 to 2019? Why it has come? So just 2-3 minutes, I want to share my experience as a advisor to Minister of Consumer Affairs, Government of India. I involved from day one till today in drafting of this Consumer Protection Act 2019 and rules and regulations. And also as a students or as a faculty, why we are teaching Consumer Protection Act along with law of torts. Why Motor Vehicle Act along with law of torts. So there is an object behind it. So all those things we should look into. As you know, the law of torts not that much developed in India, except absolute liability principle. We have not developed in other areas. But the common law system or tort principles recognized in our statutes, especially Consumer Protection Act. So that's why that particular Consumer Protection Act added in law of torts. And also the Motor Vehicle Act. Motor Vehicle Act as a whole act is not covered. Only some important points, especially no fault liability, insurance part. To that extent only we are covering under this particular subject. In National Law School, we are teaching in two independent subjects, Law of Tort 1, 2. One is completely Law of Tort Principles, 2 is completely consumer welfare legislations, including Consumer Protection Act, Bureau of Indian Standards Act, Legal Metrology Act, Food Safety and Standard Act, the regulatory authorities, ombudsman, as a consumer centric, how he can get the help from all these things. So in that way, we are teaching. And the 1986 Act in 2008, I joined as a chair professor at National Law School. Then I'm directly associating with the secretaries of Ministry of Consumer Affairs. During that time, we thought of amending the 86 Act. So we were having only, we want to bring regulatory authority and whatever loopholes in the 86 Act, especially enforcement power, execution power, and other aspects. Misleading advertisements were not were very big one. So these are the areas. Along with that, we want to cover endorsers liability. During that time, we want to remove the second chapter, Central Consumer Protection Council chapter, which was just like a rubber stamp. Nothing was working. So we want to remove that. We want to add Central Authority chapter and the other the sections to amend. But that was happened in 2013. There was a bill, but not moved ahead. Then in 2014, election came, Congress government gone and BJP government came, and Ram Vilas Paswan took a cabinet minister of this consumer ministry. Then the secretary and everybody thought of, let us come out with a new legislation instead of amending all the sections in the 86 Act. That's why 2015 bill, Consumer Protection 2015 bill, introduced in Lok Sabha, but Lok Sabha referred it to the standing committee, parliamentary standing committee. Again, parliamentary standing committee, as you know, around 20-25 people, MPs of all the parties are in that committee. And they invited all the experts, all the stakeholders of throughout India. So I was also went to Parliament and gave my experience input on that. After that, the committee submitted its report to the Parliament. Parliament once again sent back to the ministry, and again ministry constituted a committee to review what they have suggested, what we can add in the 2015 bill. Then with some changes, the central government introduced Consumer Protection Bill 2018. And when 18 bill was introduced, during that time, again, election announced. So that bill was lapsed. Then in 2019, ultimately, the bill was introduced and approved, passed in Lok Sabha, Raj Sabha, then the president's signature, and it was notified in August 2019. So Consumer Protection Act 2019 notified in the Government of India Official Gazette, August 2019, immediately it has not came into force. But again, it was notified in 2020 in 3 dates, 20th July, some provisions, 23rd, 24th, some regulations, rules. Ultimately on 24th July 2020, whole legislation came into force, including Jammu and Kashmir. Earlier, 86 Act was excluding Jammu and Kashmir. This one including, because that special status was removed. So in that way, this particular act came. And what is the difference? Mainly, Justice has covered just 4 new chapters, which was not there in the 86 Act. First one, Central Authority added, then Mediation chapter added, then Offences and Penalty chapter added, then last one, Product Liability chapter. These are the 4 new chapters. And whatever words used in these new chapters, those words definitions added in section 2. Usually section 2 contains definitions. And along with that, the 86 Act provisions, they brought it in 2019 by amending these sections. Whatever loopholes were there, they have removed and in 2019 introduced. So this is the 2019 Act. This one we are discussing in detail. Basic thing is, yes, as you know, United Nations guidelines on consumer protection, 1985, those broad guidelines and our constitutional fundamental rights. On that basis, state has a duty to enact a consumer welfare legislations. So hence these welfare legislations and including Consumer Protection Act. So it is the duty of the state to protect. And that's why and we should be proud that India is the country which is having independent redressal system exclusively for consumers, which is not in other countries. In other countries, they have added in the existed redressal system. They have not established any independent one. So in this way, it has its own importance, value, and other countries are also looking at India, especially on Consumer Protection Act. And whenever the foreign business people are entering into India, first they study how Indian laws are working, what are the consumer protection is there. On that basis, they plan strategies and enter the market in India. So these are the other things which are very important. So we'll discuss in detail during my session. With these words, thank you very much for giving me this opportunity.
Thank you, sir, for sharing such valuable information with us. I now request Dr. J.M. Malika Janaya, Principal of KLE Society's Law College, Bengaluru, to deliver the presidential address.
Thank you. Honorable Mr. Justice R.K. Agrawal, President, National Consumer Dispute Redressal Commission, our beloved friend, Dr. Sm Kantikar, member, NCDRC, a dear friend of KLE family, Dr. Ashok Patil, Chair Professor and Chair on Consumer Law and Practice at NLSIU Bengaluru. Dear student friends, distinguished delegates, dear alumni members, my dear colleagues, and all other invitees. At the outset, I congratulate the conference committee for having organized such an important seminar on an important topic, rather. I also express my deep sense of gratitude to the president of NCDRC and the member for making it to join us all the way from Delhi. My deep sense of gratitude is also due to the chair on Consumer Law and Practice at National Law School of India University, headed by Dr. Ashok Patil, for bringing us this wonderful opportunity. Well, on the occasion, I was wondering how to emphasize the importance of consumer protection. Of course, in my words, though all of us understand that consumer protection is important, while emphasizing the importance of capital and labor for the existence of an industry for economic growth of the country. Once Pope Leo said, industry cannot run with the help of one. Capital needs labor, labor needs capital. The organization, coordination, cooperation of these two is essential for the establishment of continuation of industry, which is very important for national progress. While Pope Leo said that, in the Indian context, very interestingly, Mahatma Gandhi, in a way, revised it. For me, it sounds like a revision. With the idea of trusteeship, he suggests capital needs labor, labor needs capital. In other words, capital employs labor, labor employs capital, and the community employs both of them. Consumer employs both of them. Thus, the consumer always is the king of kings, is what I understand. There is always a necessity, justification, need to protect continuously the interests of this king of the kings, consumer. What has been done in this direction? As you may recall, a lot has been done in this direction to protect the interests of the consumer class. For me, the early instance of protection of consumers through law is with the emergence of judge-made law, and at the head, uniform contracts or standard form contracts. In other words, the protective devices evolved against the standard form contracts. Since then, till 2019 CPA, lot of efforts have been done. Apart from uniform or standard form contracts, the next piece of law is the Sale of Goods Act. Thereafter, we have come up with the exclusive enactment in 1986 with the Consumer Protection Act. I don't know whether it was inadequacy of the law or growing need to protect the interests of the consumer. CPA 1986 was found inadequate, and CPA 2019 is in place now. So in protecting the king, a lot of legal developments have happened. And I'm glad that today we all have gathered here to understand the latest developments in this very important aspect of protecting the interests of the consumer. A new law is in place. None other than the president of the NCDRC, member of NCDRC, and my dear friend Ashok Patil, Dr. Ashok Patil, who is there with this consumer chair for last 14 years, deeply involved in policy making, understanding the working of the law. All of them would be taking you through various aspects and trying to bring their experiences. And I believe it is an opportunity to know from the horse's mouth. I would appreciate all of you to attend all the technical sessions. Appreciate and appeal to all of you that you understand, you participate with the utmost attention in all the technical sessions. Try to understand the first-hand experience from the members that are with us. Let's know, then understand, comprehend, organize, and evaluate the knowledge that we get. I think with this appeal, I thank you all for a very patient hearing. Thank you.
Thank you, sir. I now request Dr. Mahesh R.S., faculty convener, to render the vote of thanks.
A very good morning, everyone. Honorable dignitaries on the dais, distinguished delegates, alumni members, invitees, and dear students. I deem it a privilege to do this pious job of proposing out of thanks to this august gathering. First and foremost, I would like to extend my deep sense of gratitude to the chief guest of today's function, Honorable Mr. Justice R.K. Agrawal, President, National Consumer Disputes Redressal Commission, New Delhi, for gracing the occasion and delivering the inaugural address. Thank you, sir. My sincere gratitude to the guest of honor, Honorable Dr. Sm Kantikar, Member, National Consumer Disputes Redressal Commission, New Delhi, for his valuable presence and consenting to be the resource person for the seminar. Thank you, sir. I'd also like to extend my thanks to another guest of honor, Dr. Ashok R. Patil, Chair Professor, Chair on Consumer Law and Practice and all the members of Chair on Consumer Law of National Law School of India University, Bengaluru, for his initiation in conducting this seminar and also for his kind support and guidance. Thank you, sir. Now I'd like to thank our beloved principal, sir, Dr. J. Malika Janaya, for his constant motivation and also for presiding over the function. Thank you, sir. I congratulate and thank all the delegates, participants of legal fraternity who came across the country to take part in the academic discourse. Thank you. I also thank our IKC coordinator, Dr. Manoj Kumar V. Hiremat, for his continuous support for organizing this seminar. Thank you, sir. I'd like to thank all the student volunteers for their tireless efforts towards the connect of the program. I owe my sincere gratitude to all the faculty members and supporting staff who were exceptionally helpful in extending their kind support for conduct of the seminar. I would like to conclude with a quote of Mahatma Gandhi ji about the consumer, wherein he says, like, a customer is the most important visitor at our premises. He is not dependent on us. Rather, we are dependent on him. Thank you. Thank you, everybody.
Thank you so much, sir. The inaugural ceremony concludes here. I request our faculty members to gather at the front of the college building for a photo session. We will now have a tea